Hi, everyone. I am delighted to be speaking here with Chrisbens, a person who I have met 7, 8 years ago when I worked at Smart Recruiters and was building the OFCCP, actually the global compliance product, in order to make sure that companies would be able to be compliant in the US and Europe and various countries. I came across a really insightful write-up where Chrisbens was one of the writers, reached out to him, and we've developed a friendship because it was so helpful. Chris has closer to 35 years of experience practicing law. He's a current principal at Silberman Law, focusing on affirmative action planning, OFCCP compliance, pay equity, diversity and inclusion practices. And given the recent activity around diversity, equity, inclusion, dating from a big wave for and then a recent backlash against, figured it'd be a really cool conversation, open-ended conversation to talk about these specific topics with Chris so that we can all, including myself, learn a few things and always stay on the right side of the law. Chris today is the principal at Silberman Law. You had mentioned that. And welcome, Chris. Super happy to be talking to you.
Yes, it's great to see you again and have the opportunity to chat about topics that are near and dear to our hearts. Look forward to it.
I'm going to go right into it and into what I think is the toughest question to answer, maybe because it's subjective, which is what is DE&I in the eyes of the law? Is
Yeah.
it I'm here to hire from underrepresented communities where there's a higher unemployment rate within these communities, such as, for example, the blind, the deaf, the elderly, proactively hiring from these communities? Or is it more of hire the most qualified person from a diverse pool? Or is it something else?
Yeah. And I'm going to give you, I think, an answer that's going to be a little bit surprising to you. And that is that DEI is not a product of the law in the United States. It is something different that has grown up and evolved almost outside the law. And let me tell you what I mean by that.
Mm.
We have lots of anti-discrimination laws in the United States, right?
Mm-hmm.
Civil Rights Act of 1964, principally, that says thou shalt not discriminate based on a number of protected classes.
Mm-hmm.
And within those laws, there is a complete absence, essentially, of DEI topics, right? It's not what you should be doing to create diversity, equity, or inclusion. It's thou shalt not discriminate.
Mm.
DEI has sort of grown up outside that, but subject to that, right?
Mm.
There's one exception, a couple exceptions. One exception is the one that you mentioned in your introduction, which is affirmative action obligations of federal contractors as enforced by OFCCP, the Office of Federal Contract Compliance Programs.
Mm.
And that area of the law is a product of the government's belief that if you want to do business with the federal government, which is a privilege, then you have to do extra things to compensate for that privilege. And those extra things are not only not discriminate, but take affirmative action to attract women, minorities, veterans, and individuals with disabilities to your workforce so that over time your workforce comes to look like the labor markets from which you draw.
Mm-hmm.
And so that's sort of where affirmative action has that's my world of affirmative action. There's actually another exception, which is very topical, which is the area of higher education, right? We know the Students for Fair Admission versus Harvard and University of North Carolina case recently, which upended years and years of Supreme Court precedent that allowed institutions of higher education to account for race and ethnicity in their admissions practices. And I refer to it as the Harvard case. And the Harvard case said, no, discrimination is discrimination. There is no justifiable reason to take into account race when you're admitting students to higher education. And again, as I said, that upended years and years of precedent. And it really has unleashed a backlash against DEI. You know, the term affirmative action now, I think, is very much misinterpreted based on the Harvard case. And the Harvard case is what it is, right? The court decided that, hey, you know, these laws are pretty clear on their face that we should not be discriminating based on those protected classes. There just really isn't any basis to allow that in the world of higher education. And those who are, I'll put it mildly, skeptical of DEI practices in the corporate world have seized upon the Harvard case to say, hey, Harvard says you cannot make employment decisions based on race, gender, ethnicity. That's not what the Harvard case says, but that's what they're arguing by extension. And truthfully, from a legal perspective, that's not a bad argument, right? Because Title VII of the Civil Rights Act of 1964 also says, thou shalt not discriminate.
Yeah.
So I think in the world of DEI these days, those who are skeptical of DEI efforts are misinterpreting Harvard and assuming that corporate America is as part of their DEI programs, are making race, gender, ethnicity, employment selection decisions. And I would say that for the most part, that is a misunderstanding, a mistaken assumption about what a corporate America is doing. And they are seizing upon language DEI programs that they believe suggest that that's what's going on, when in reality it's not really what's going on. Now, certainly there have been for many years companies who are pushing the DEI envelope, who are to some degree using race, gender, and ethnicity to make employment selection decisions. But as I say, by and large, that's not really what's going on. So let me pause there.
So let's say I'm a head of talent acquisition and I've got a C-suite at my organization. They're all white males. The CEO comes and says, I worry about hiring my next C-suite exec, my chief product officer, and I'd be worried if this person was another white male. So let me ask the staffing agency that I'm using right now to get me a slew of diverse job seekers through race, ethnicity, or any kind of disability in order to create more diversity. How far can I go in this argument, in this push, or should I not?
Yeah, great question. So here's what I like to call the bright line, which is the law in the United States with one exception. Bright line right here. On this side of the line is our outreach, our recruitment efforts, everything that we do to go out and beat the bushes, so to speak, to attract a diverse pool of candidates to our doorstep to apply for open positions. That is the essence of affirmative action, right?
Okay.
Affirmative action says, look, if our workforce is a bunch of white males and the labor market from which we draw is much more diverse in terms of race, gender, and ethnicity, something is wrong there.
Yeah.
Either one of two things is going on. One, you have barriers to equal employment opportunity, right? whether those barriers are a product of intentional discrimination or unintentional discrimination,
Mhm.
affirmative action says there's something going on there. So what
Yeah.
you need to do is look at your personnel processes and procedures and policies, identify those barriers and fix them, right?
Mhm.
And the other is, well, maybe you're just not doing a good enough job of positive recruiting. Maybe you're not out there beating the bushes trying to attract a diverse pool of candidates, right? So the law says once you get people to that doorstep, to your open positions, and you cross that line into making screening decisions, winnowing
Mhm.
that pool of candidates down, that's when consideration of race, gender, ethnicity, protected status has to end, right?
Got
You
it.
cannot make employment selection decisions based on race, gender, and ethnicity. And that's where the the line has gotten a little bit more fuzzy,
Yeah.
where people have tried to sort of bend that
Mm.
line. So just for fun, let's
Mm.
talk about one US Supreme Court exception to that
Mhm.
bright line. And
Mhm.
you know, this is very esoteric. Nobody nobody really knows about these cases, but they're
Mhm.
really important cases. And they're known as the Weber and Johnson Supreme Court cases. In
Mhm.
those cases, very similar to admissions to institutions of higher education, said, look, Title VII of the Civil Rights Act isn't just an anti-discrimination law. It is, to a certain extent, a remedial law. It is intended to help remedy the past effects of discrimination. So if an employer can identify a manifest imbalance, that's the term of art, between availability of women and minorities in a labor market from which they draw and representation in their workforce,
Yeah.
which is in a traditionally segregated um, area of the workforce, then you can, to a very limited degree, make employment selection decisions to address that manifest imbalance. If you do so in a very narrowly tailored way to fix that particular issue and no more, and not unnecessarily trammel the rights of others, meaning essentially white males. And so
Let
that
me just take a quick summary of the three cases that we looked at so far. So first, we've got an affirmative action, I don't know if it's a law or a case in the 60s that came out that says you have to protect like you cannot discriminate against various communities. Then we have the Harvard case. When did that happen roughly?
Yeah, so I mean, in these cases we're talking about, you've got the Civil Rights Act of 1964, and there were other anti-discrimination federal laws before that arose out of slavery. But the Civil Rights Act of 1964 obviously was a product of the civil rights movement of the 60s. Then you had the Weber and Johnson cases, which are late 70s, early 80s cases. And it's interesting.
That's allowed to have some exceptions in order to address an imbalance. So if, for example, I don't have a single Black person in my organization, I want to come and address that imbalance, and I can come and show that the flow of candidates who are coming in who are Black do not represent the overall population in my city or country where I'm hiring. Then I can, in those limited cases, prioritize a Black person. That's what this one is saying.
That's right. You can consider that person's race, gender, and ethnicity in making a hiring or a promotion decision in order to address that manifest imbalance, right? So,
Mhm.
and then so there's another component of the laws that led to the Harvard case, and those are
Roughly
the
what year?
boy. The higher education cases, I mean, they were probably started in the 70s.
Okay,
And
okay. So way back a while
yeah,
ago.
they grew, right? I mean, and the idea was that diversity on campuses of higher education institutions was a fundamental need, a fundamental part of an education was to be exposed to a diverse student body and a diversity of thoughts. And therefore, that was a compelling interest that allowed those institutions to consider race, gender, and ethnicity in admissions to create that diversity. And the U.S. Supreme Court pulled the plug on those cases in the Harvard case. Harvard case said, nope. I mean, it didn't say this essentially. Well, it didn't say it exactly, but it said it essentially. No more use of race, gender, and ethnicity in admission cases. So if you want to look at it this way, you've got the Weber and Johnson cases in the employment context, and you've got the, I'll say the higher institution cases in that context.
Yes.
So Harvard got rid of the cases in higher institution. I would tell you that today, if the Weber and Johnson cases came up before the Supreme Court, they would be overruled. Absolutely, positively, this Supreme Court would overrule them, right?
The right path, like the most effective path, if I understand correctly, is to say, be sure to have a diverse slew of candidates that represents the overall population based on as broad a diversity metrics as you can have, including age, including disabilities, including make sure that your site is accessible, your hiring process is accessible. Like if you've got a blind job seeker, make sure that your career page is accessible so that they don't drop off. So make sure once you have that pool that represents the overall population, then make no regard to the diversity mix and hire the most qualified person.
That's exactly right. You're exactly right. And the only exceptions were the Weber and Johnson case and the higher institution cases, and both of which are essentially gone now. And that has rocked the world of DEI, right? Because especially post George Floyd murder, we took off on DEI. We've got to do something about this. We've got to address this issue. And, there were some organizations that were pushing that envelope, right? I mean, there's now, just in the last year since the Harvard case, there are dozens of cases attacking DEI. Let me give you an example of one. So Pfizer, the pharmaceutical company, great company, had this wonderful fellowship program that was essentially, or I would say, had a set aside for people of color in its fellowship program. Its fellowship program was for persons of color. Sounds great, right? Because, hey, a disadvantaged group of people, we're just giving them a leg up, helping them do better within Pfizer, helping them get jobs at Pfizer. But again, arguably, that was an employment selection decision, a fellowship, a paid fellowship. And those decisions were, to a certain degree, being made based on race and ethnicity. And, it was right out there in the open. And post George Floyd, who's going to attack that, right? I mean, this is all good stuff. But then come along these organizations, those who are skeptical of DE&I practices, and they say, wait a minute, time out here. We have anti-discrimination laws that say you can't make those employment selection decisions based on race, gender, and ethnicity. You are violating the law. And ultimately, Pfizer said, we're not going to fight this. We are going to change that fellowship program. And that's exactly what they did. And that is the process that we're going through right now. Some organizations, I would say, are very principled in their attacks on DEI. They are finding organizations and they are finding specific areas where they think those organizations are across that bright line. And they're saying, we're asking you to stop doing that. And they've been successful. There are other organizations using the pushing the envelope metaphor, who are pushing the envelope the other way. They are making assumptions about what DEI programs are doing that I think are misinterpretations, that are mistaken assumptions, right? Because they see we have a goal to increase the representation of people in color in our organization to 45%, they are assuming that those organizations are making employment selection decisions based on protected status. And they're really not, right? And so in my world, what's going on right now is sort of this, okay, we've got a different world now. We've got a risk spectrum here. And where do you want to be on that risk spectrum? How much risk do you want to take in your DEI program? Do you want to pull back and go back to the core principles of DEI and affirmative action? Or do you continue to want to push the envelope a little bit because that's what you think needs to be done? You're willing to take the risk in order to show results in your DEI program. That's really where we are right now, shaking this all out. And so a lot of what I do is work with corporations on DEI assessments. Let's take a look at your DEI program. What do you say you're doing? What are you actually doing? Where are the risks? What's your risk tolerance? And how do we put that all together to keep your DEI program on track and mitigate risk?
What are some of the main elements that you look at once you do work with a company on that topic?
So there's probably a laundry list of 6 or 7 things that we look at. One is your diversity goals, right? We know many companies out there have a goal to, a percentage goal representation of women and minorities, right? Yes. Well, number one, how are you setting those goals, right? Because if you're just saying we want, 45% women in our C-suite by 2025, what is that based on, right? Is it based on the availability of women who are qualified for those kinds of jobs? Mm. Or is it just kind of pie in the sky? If it's pie in the sky, the argument that the DEI skeptics are making is, look, that is a naked preference for women, right? Because there's no basis for believing that you should have 45% women in your C-suite. And that goes back to that concept of underutilization or underrepresentation and manifest imbalance, right? If, let's just use an extreme example. If the data tells us that there are only 15% women who are qualified for those sorts of C-suite jobs in the labor market from which you draw, then 45% as a goal makes no sense. It is essentially a naked preference for women in the C-suite. And that's where you create risk. Now, I want to be careful about something. When we talk about availability of women and minorities for certain kinds of jobs, I get very self-conscious, right? Because, if you say, well, there's just aren't qualified people out there for these jobs, then it's sort of a self-defeatist sort of perspective. And certainly a large part of what DEI is about should be, how do we increase the population of women and minorities who are qualified for those kinds of jobs? How do we go about creating that pipeline? And that's one of the saddest parts about the Harvard case. If Harvard can't use race, gender, and ethnicity as a criteria for admission, so we create that pipeline of disadvantaged people who are now educated and qualified for those kinds of jobs, then you've cut us off at the knees to a certain degree in terms of creating that pipeline, right?
Yeah.
And so, but that's one of the areas. Those goals or target representation, goals and targets, how they are set. Number two,
Click on that first one. How does one determine what is the right percentage? So I would think that, let's go with a gender example. Between male, female, non-binary, and people who just don't identify. But if you just take just the male and female bucket among that, roughly 50-50. Education levels, life expectancy, roughly 50-50 in the United States. And therefore, if right now there is a 20% representation of women at a particular segment of the management hierarchy within an organization, then wouldn't it be a fair suggestion that it ought to be 50-50? And we can go into the reasons as to why it's not 50-50, from applicants to upbringing to like hires like to culture. But putting all that aside, isn't 50-50 a defensible benchmark?
Yes and no, right? I'm going to start with the no, and this gets into what we do in the area of affirmative action for federal contractors, right? So, let's say we're looking at a group of managers in a federal contractor's workforce, and we only see 10% representation of women in that managers category. What we do as federal contractors is we look at census data, right? And census data, and it's a blunt tool. It is a very blunt tool. Let me be very clear there. But census data tells us for any geographic area, the entire United States, a state or states, county or metropolitan area, what is the percentage of women in that area that are qualified, who have identified as qualified for that kind of job? And we can look at that. So if the representation of women in our managers group is down at 10%, but availability is up at 40%, then we have that manifest imbalance. We are underutilized, right, for qualified women in that segment of our population. But if the availability of qualified women in the labor market we're looking for is at about 10%, then we're not underutilized, right? And so that's one perspective, right? What that perspective ignores is what I was talking about a minute ago. Why is that population of women only 10%? Why isn't it closer to 50%, which would match the population of men and women, right? But that's the sort of rub there. You can't expect to reach that 50-50 level in your manager's group if the percentage of qualified women in that labor market isn't that high. And so, and that's it's human nature to want to solve a problem in the easiest way possible, right? And the easiest way is, hey, let's go out and hire more women, right? But that's not always the best solution, or it's not even the real solution to the problem, because the real solution to the problem is over here. It's education and training and opportunity for women to become qualified for those manager positions. That's where, I would say the real problem is, but that is part of the problem, right? But you can't short circuit things by saying, okay, Roy makes a good point. The representation of women and men in the United States is 50-50. So why not have a 50% goal for women, right?
Yeah. So what about if we're saying that the bottleneck is upskilling, that women historically have not had the opportunity to be at that senior management position, a smaller percentage has that actual training, and therefore, or maybe management is a bit more,
Mhm,
might be less uh, quantitative as, for example, development,
mhm,
programming,
mhm,
where you can say what percentage of the Python developers are, male versus female versus non-binary and whatnot. So let's go down that example.
mhm,
Uh, then you've got, if you identify and say, all right, the current percentage is 30%, you want to put a target of 30%, that's very defensible, fine. But then when it comes to the training, you want to get the training up to 50% because 50% is the population. You've got that gap of 20% of the overall population that ought
mhm.
to go up. So then you've got some grants and funds and programs that go and boot camps that will create these upskilling opportunities. Are they allowed to, in perfect defensibility, prioritize women in order to reach that gap?
You are you are great at this, Roy. That was an excellent question. So it depends on the context, right? If I'm an employer and I have a population of employees and I want to increase the population of people who have a certain expertise or a
Mm,
skill, um, arguably, if I say, okay, I'm going to institute a training program and I'm going to limit that training program to women,
mm,
the law is going to say well, and this is an unsettled area, but it's becoming clearer due
mhm.
to a Supreme Court case that literally came out late last week or early this week.
Oh, wow. Oh, well, tell us about it.
Yeah. Well, let me finish this example.
Okay,
So
okay, okay. And then
the
we'll get to that.
the risk is that if you say that's a training program and we only want women in this program, sorry, men, a great population of men already have that skill. We're focusing on increasing, what'd you call it? Upscaling?
Upskilling. Yeah.
Yeah, upscaling. The upscaling is needed for women, not men. Well, that's that Pfizer case. That's the fellowship we had to set
Yeah.
aside for people of color, right?
Yeah.
And
Yeah.
so that is potentially discriminatory. And so, no, you can't do it that way. So you almost have to do it outside the context of employment, right? You have to do it in a way. Well, you just have to do it outside the employment context, almost. Which isn't to say, hey, we have this training program, and we're going to play it very safe and say it's not limited to women. But guess what we're going to do? We're going to encourage as many women as we can to participate in that training program. We're not going to exclude men, but we're really going to focus on trying to get women and other disadvantaged folks to participate in that training program to create that pipeline. That's what we're going to do. So the case I'm talking about, this goes off in a tangent, which I don't think we really want to
Okay,
go.
we can. Oh, okay. Whatever. Just a bit of a snippet, just because this is an actuality.
Yeah. So this case is called the Muldrow case, right? And the Muldrow case addressed the issue of if I as an employer, well, if I as an employer discriminate against you in your terms and conditions of employment, what is the degree of discriminatory harm you have to suffer before you have an actionable claim of discrimination, right?
Mm.
Well, that sounds kind of silly, right? Because isn't discrimination discrimination? And why do you have to have significant harm for that discrimination to be actionable? And that's
Mm.
what the Supreme Court said in Muldrow. And I am expanding that case greatly. And what it said is, look, all you have to have is some harm as a result of that discrimination to have an actionable claim of discrimination. So what happened in that case is a woman got transferred to a different job, same pay, same for the most part, the terms and conditions of the job that she was transferred were the same. But there were other things that made that job less attractive to her, a worse job than the one she had. And so the argument was, hey, you don't have an actionable claim because there was no significant or material harm to your employment. And the court said, there's nothing in Title VII of the Civil Rights Act that says you have to have significant or material harm. There only has to be some harm, right? So that's a huge case, right? Because, and it's limited to transfers. But if you take that principle and expand it, then any sort of employment selection decision that might have been a product of discrimination is actionable if there is just at least some harm, right? So that applies to the world of DEI and discrimination because, let's say we haven't talked about diverse slates, and that's a whole nother thing we could talk about. But let's say that we advance a candidate to an interview slate, a person who is even, substantially similarly qualified to the other candidates, but we advance that person to a diverse slate because she's a woman or because she's a person of color or because he or she is disabled, because we want to create diversity. Well, if you expand the Muldrow case, that may be an actionable harm because for that applicant or for other applicants who didn't get advanced, because it is a step towards employment, right? Yeah. And so that case is going to be important. It really has the potential to change a lot of what we're talking about and make what I'm saying even more risky. So
yeah, I see what you're saying.
Yeah.
And so therefore, in order to defend diversity, one ought to be able to source from a diverse pool and then from there hire the most qualified person.
That's right. I mean, that is the basic foundation of our discrimination laws in the United States, right? It is qualifications, not your immutable characteristics, right?
Okay.
That is the principle.
Nowadays, so I'm going to take us down maybe a different path than kind of the audit within DEI, because we only covered, like, I would say, step one, what are the benchmarks and how do we get to them?
Right. Yeah.
But if you go down the path of the original question, which is hire the most qualified person from a diverse pool. Nowadays, it's become very easy to apply to jobs. You've got one-click applies through most job sites, and therefore there are more applicants, arguably, per jobs, and creating a lot of pressure on recruiters to be able to evaluate all resumes. They're only human after all. And so it's hard to go through every single resume. And oftentimes there are a lot of things in the resume that they don't understand. Like, for example, things that are really deep down in bullet points under a particular company, different job titles are similar, that are more effectively understood by artificial intelligence engines because they've got that full context, that a lot of rich data to be able to understand the relevance of, for example, the connection between a program manager and a product manager and a project manager. That, or one skill versus another, or transferable skills that, because they're somewhat related, that an individual might not, outside of not having the attention span. Therefore, you've got a big push towards the use of AI in recruiting.
Yep.
What does the law say about the use of AI when it comes to recruiting?
And that's another huge topic right now, obviously, which is why you asked the great question. So let's be careful about terminology, right? You say artificial intelligence, AI in recruiting, right? Because I'm going to go back to that bright line, right? if you want to use AI in your recruiting to try to attract a diverse candidate pool to your doorstep for consideration, have at it. As long as you're not excluding some groups as opposed to other that you're recruiting for, you're fine. I mean, that's what you ought to be doing. Well, ought to be doing.
Yeah.
But once you cross that line into screening, that's where AI becomes, I don't want to say problematic, although that is the word, where it gets interesting, right? Because we want to use AI because we don't have the bandwidth to do it all, right? We want to use artificial intelligence to find the best candidate. And the problem with AI, and if I haven't said this already, I'm going to be very careful. I am not an AI expert at all, right? But AI is problematic because in attempting to achieve what you want to achieve, the unintended consequences may be bias and prejudice, right?
Yeah.
There's a great book out there. Well, it's a great book. It's an interesting book on AI in the employment context. And I wish I had it in front of me. And I'll find it and I'll send you the book. And what essentially this book is saying is, look, AI in the employment screening context is a wreck. And by that, I mean, it doesn't work. It's not doing what people think it's doing. It may appear to be doing what people think it's doing, but it's not. Number one, it's not achieving what you think it's achieving, meaning trying to find the best candidates for a particular job. Yeah. And number two, it is terribly biased in some instances against certain groups of people. That's the premise of this book, and how do we fix it? And that's where we are right now at the present moment. Government agencies and state and local governments, federal governments are getting in on this and saying, look, we have to prevent AI from handicapping certain groups of people in something as fundamental as access to employment, right? And so I think, again, non-expert here, I think AI can work, right? But it needs a lot more attention by real experts. And I think not just attention, but a lot more analysis on whether AI is actually working in the particular context in the way that you think it's working or in the way that you want it. And so, in terms of being topical, OFCCP just, what's today, Wednesday? It must have been yesterday or Monday, issued guidance for federal contractor use of AI. It's a fascinating document. It's a very basic document, but EEOC in the United States has also issued guidance on AI. And I think, I think this is, there's a lot of fascinating things that are going on, right? But I think this is probably the most fascinating. I mean, because it really is the intersection of employment and high technology, and how is this really going to work? And it is an opportunity to say, okay, AI can be great, but we've got to make sure that it is great and really works the way it's supposed to work.
I'd love to, as well as the book that warns that it's doesn't work, but also to get those guidances by the EEOC and the OFCCP, and potentially at some point have a session on the guardrails of AI within employment, because that's a topic that I'm deeply interested in. What are some of the most common cases that you come across when someone who's another entity and that you have to then defend? Maybe without, giving any specifics, but like, what are the main buckets that you do see for anyone who's interested in the topic, is in talent acquisition or is in HR, and
Mhm.
wants to keep an eye out on to make sure that they're doing things right?
Yeah, and you would think that I could give you an answer to that, but there, I mean, I would research the Pfizer fellowship case.
Yeah.
I think that's a very interesting one. But these cases are also new. They haven't really gotten very far. These
Mm,
cases attacking DEI. But there are all kinds of cases for
yeah.
decades on reverse discrimination, right? And that's essentially what we're talking about, right? It is certain people saying that because your DEI program is focused on people of color and other disadvantaged groups, that you are essentially engaging in reverse discrimination against white males. And that
Mm,
just embarrasses me, right? As a white male, that just embarrasses me.
mm,
But nonetheless,
mm,
that's where you really can see, what's going on. And there
mm,
are reverse discrimination cases out there in the last 3 years that deal
mm,
with DEI.
mm,
There a recent case, and I don't know the name of the case, but if you just went on a search engine and
mm,
search reverse discrimination, you'd find these
yeah.
cases. But a white male is awarded $1 million+ in his claim that he was forced out in favor of women of color in a particular job. And what these cases do is say, well, look what they're doing in DEI. Look at everything they say about DEI. And of course, they were discriminating against me in favor of these women of color. So,
Mm,
that is one of the buckets of risks for DEI program companies
mm,
is a reverse discrimination claim by one of your employees. So I
mm,
think that's an area of the law cases that you can look at and get a flavor for sort of the
mm,
individual
mm,
claim. The other buckets of cases are sort of those cases that are driven by organizations that are skeptical of DEI, and they want class action cases on behalf of applicants or employees and so on and so forth. And those are the ones that are really intended to create a media splash and draw media attention. That's what these organizations really are about, is garnering public attention to DEI and what they think DEI really means in the context of a particular company, because they want to generate outrage. Well, how dare these companies discriminate as part of their DEI program against anybody? Right?
mm,
They
mm,
shouldn't be discriminating in favor of any group, because we have laws in the United States, and those are anti-discrimination laws, and they are race, gender, and ethnicity neutral, right? They're
yeah.
trying
Yeah.
to generate that sort of outrage. And those are the cases that, by and large, haven't gone very far yet, because most
Okay.
of them, and this says a lot, like the Pfizer case, hey, you shine a light on what's really going on there. Companies don't really want to litigate that.
Yeah.
They're gonna settle those
Yeah.
cases. So Ed Bloom, he was the guy behind the Harvard case. He's a guy behind other cases, and I would say he's more the principled person. He's saying, well, look, let's look at this little area of what you're doing here. Doesn't that really look like discrimination? And
Mm,
what he's been effective in doing is shining a light on that, and then persuading these companies to back off of
yeah.
that.
Yeah. Yeah. Yeah.
Yeah,
What other buckets, like pay equity, for example,
yeah.
or cases like blind people not being able to access the site, or someone who's formerly incarcerated not being able to apply not apply, but get an offer because of the background check.
Sure.
There's so many different nuances, or elderly people not being able to get a job because it's they're favoring the
Age.
young.
Yeah, for
Yeah.
sure. And yeah, I mean, it's an exciting time in all of those areas. And um, I mean, I am less of an expert in disability and age discrimination than I am, but you're absolutely right. What is going on in the world of DEI in terms of race, gender, and ethnicity is also going on in the world of age and disability and LGBTQ and in all of
Mhm.
that. It just doesn't get quite the same attention, but absolutely. I mean, and the other thing, well, I mean, especially for individuals with disabilities, is who wants to attack a company that might actually favor to a certain degree individuals with disabilities, right? I mean, that there's no benefit in that.
Yeah.
And that's a different context too, because there's no such thing as reverse discrimination in terms of disability.
Hmm.
The fact that you are not disabled is not a protected status, right?
Yeah. 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 Yeah.
Um, but we're just in another sort of phase of of evolution, I would say, as to how we want to deal with disadvantaged individuals. And it's the pendulum, right? I mean, the pendulum swings one way and the other, and it may swing this way and may inch back, and that's kind of what we're seeing right now.
Yeah. Um, Last question I have in mind is what about organizations that are like membership organizations and that specifically work with one demographic? For example, um, you got Lighthouse for the Blind on one side, which
Mhm.
is basically saying, okay, being not blind is not a protected class. But what about an organization like the Society of um National Black MBA community society,
Mhm.
Nashimba, Nabimba, NESB, so National Society of Black Engineers.
Right.
Uh, can
Those are great.
someone?
That
Okay.
that's where you know I want to be careful. That's where this work should be done. That's
Hmm.
where in the long term the results and the benefits are going to come from.
Hmm.
Because going back to my bright line, that's all over here, right?
Sure.
That's that's training and education and building that pipeline of
Yeah.
people are going to, I want to say, naturally make it into the workforce and up in
Into the
the
employment.
workforce because they are the best qualified and because there is a mass of people who are qualified.
Yeah.
And so, again, it's like human nature. Well, I would see this problem. Let's fix it in the easiest possible way. And that's where we get into a little bit of trouble, when what we really need to do is the harder work over here. That's what I
Hmm. That's super insightful.
Not really.
It is. It's I haven't had I would say that the definition or the yeah the I would say the most effective way to look at hiring through a diverse lens and then seeing that clear line
Mhm.
delineate one in the spirit of employment, the other one in the spirit of upskilling,
Yeah.
um, then setting goals based on where you're at.
Mhm.
Of course, I mean, we're underscoring, the fact that it's not an easy topic because uh, you've got case laws, and lawsuits, and then resolutions on lawsuits, and others that kind of talk about different, like there are exceptions to the rule, and in which case you can always go to this versus go to that. But if we were to go draw one global line, we can say you can have a diverse population to draw from and to hire from, and that's perfectly okay. And that once it comes to screening and evaluating, interviewing and hiring and sending offers, you want to turn you do not want to look at any personally identifiable information and hire the most qualified person.
That's right. But there's a lot that can be done there too. And so, I like to think of things in two buckets. There's outreach and there's training and education, building that pipeline, right? But there's also analysis and looking for barriers to equal employment opportunity. Why aren't women or people of color or individuals with disabilities better represented in our workforce, in this particular segment of our workforce? Why is that, right? Is it a matter of availability or training or education or outreach or recruitment? Or is there intentional or unintentional discrimination going on, right? And we have tons of data we can analyze, right? We can look at that and say, in terms of promotions, who's getting promoted and why are they getting promoted? Why are they not getting promoted into the organization? Yeah. Hires, why are people leaving, right? What is the delta in exits between people of color and white individuals, or between Asians and Hispanics, right? Tons of data that can give us a lot of insight as to where those potential barriers to equal employment opportunity exist. And then that allows us to really target those areas and fix those areas, right? I mean, and I do all of this sort of analyses for clients, so we identify that people of color are leaving this organization in this segment of their workforce at a much higher rate than white people. Why is that? Right? Let's interview these people. Let's look at the details. Let's look at time to promotion. Let's look at training and education opportunities. Let's talk to these people and see what they say about why they're leaving. And then we can really target. And one of my other favorite, and I'm just kind of going all over the place right now, is, hey, well, these are the qualifications for this job. Okay, well, when is the last time you really looked at those qualifications and thought about how they really relate to the job, and thought about, hey, could we make those qualifications more expansive, right? Because you look at somebody and say, well, according to our list of qualifications, this person isn't qualified. What if you looked at those qualifications a little bit more expansively? Would that make this person who was previously unqualified more qualified for this job? I think that's an area that is ripe for analysis and thought, right? So we could go on and on, right?
Oh, there's so much, like you're saying here in the last few minutes, that there's a lot of depth that you can still get to in order to analyze the why behind the discrepancy across various segments of society within your organization, or within those who are applying through your organization and get selected.
Right.
Chris, thank you so much. That was super insightful.
My pleasure. This was great. I love your questions. You have your finger on the pulse of all this.
Really appreciate your time. I'm going to summarize all this into something that's as actionable as we possibly can make it. Share it back with you, and then maybe do a quick iteration, and then put together a write-up. And if that works for you, and then put it out there, and then educate the wider world, who is probably confused by what to do, and is when you feel like you're doing the right thing, but there's a counter argument that's telling you, hey, no, actually you're really not, because why do I have to suffer from this?
Yeah.
You know,
And I like your word confusion. I think there is confusion in both camps. And,
exactly.
Nothing happens overnight. And I think your point is a great one, is that a large part of what we're trying to do here is address that confusion.
Exactly. Thank you so much.
Thank you.
Talk to you soon.
Take care.
Bye bye.